the court saying...
Now you guys know how fucked up America is, because it's the exact same thing as a clown house show, clown house room, and you got stupid people doing this too. See what I'm saying? Mountain Land. We have been conquered.
I also think it would be reasonable for the court just not to put them on the docket for that very same reason.
Don't put them on the docket, bitch! We got money to make!
We don't think that they should have permanent status in this case.
They ain't got permanent status, bitch! We publishing you right now! You in the news now, bitch!
They're already here. Well, no. But we do think how...
Don't you still realize we live stream in the courtroom?
The court should exercise...
It's already in the public, bitch!
Very clear what everyone's roles are here.
Hello?
And...
What are the roles, bitch? We want to know who the fuck killed Charlie Kirk.
Neutral observers.
Who the fuck killed him?
We don't want the chaos that is out in the media in this courtroom.
Well, of course you don't, bitch, but welcome. Chaos is at your gates, bitch. Hello?
Does the court have any questions for me?
No, we ain't got no questions, but why are you gonna cry, girl? Don't cry. Take a deep breath. It's gonna be okay. We're already live streaming you to Clown House. We got you.
Thank you, Your Honor. Just very briefly.
Fucking lawyer, motherfucking scum lawyer, fucking lawyer, motherfucking lawyer.
Advocate for openness.
Don't go to law school, they told me. I fucking hate lawyers, that's what they said. Don't go to law school. I fucking hate lawyers, they said. I said, you hate lawyers? Maybe I should be a lawyer. I should have been a lawyer. But now we're doing legal news.
Just a couple clarifications. Counsel said we haven't cited any criminal cases where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is the procedure that judges routinely follow, including...
This is a special accommodation because Charlie Kirk got assassinated. He didn't die in a fucking grocery store. Stick up, motherfucker!
202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings. And that rule does not technically apply to proceedings. It just applies to records. So just to be clear, but I think we have been clear, and this is all, I mean, there wasn't a whole lot of daylight between what counsel was just suggesting our role should be and what we've asked for, you know, which is just if they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with the motion to disqualify. They were able to at least provide that to us. It's not very hard to send an email. That's all that we've asked for in terms of the notice. And then we have the right to be heard on those issues. And so I didn't really hear from counsel any reason why we should not be granted limited party status in this case, other than just some sort of, you know, confusion on their part as to what that would actually look like. I don't know how the clerk deals with parties on the docket. I assume you guys can sort that out. Typically, when we intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, you know, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what it is that we are asking to do. Just one last point. Well, two things. One is that counsel's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to Your Honor an order. You know, you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical, like, deadline where we were invited to weigh in and just didn't. Last thing is, in terms of docket access, you know, Mr. Hunt and Mr. Jett and I are all officers of the court. If the court says you can have access to things that are the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. Some judges do handle it that way. Sometimes we just, you know, if they don't concern closure, sometimes we don't weigh in at all. But, you know,
what a pretentious fucking lawyer!
Under seal, and we're not allowed to see
America, this is the problem.
You know,
you hear this?
Typically, the way
this is all about how to censor,
We are allowed attorneys' eyes on
how to silo,
documents.
how to prevent the truth from coming out to the public
Counsel can see
and
things
getting
that are
this
public
jury the information they need
unless the court
to help them find the
And
truth.
if the court decides, no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are not public, that's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if